file hearing exhibits as we're having some difficulty at the office getting those filed appropriately. So I'm going to talk about that. Then we have Ms. Sorensen who's going to testify, and we have some issues related to some of those exhibits. Then we have Ms. Grunhagen, who we have a motion, and it's related to whether or not it's friendly cross or not. And then we're going to go to your witnesses. So does that help with where we're at?
Ms.
To Mr.
Sorensen won't go before me?
Yes, she is.
Oh, good.
Yes.
Okay, so if we can,
The housekeeping matter on the filings. Can we go on the record, please? It's come to our attention that in our electronic filing system, staff are having difficulty making the determination as to whom an exhibit applies. So for your information, when you log in as the registered user, your name's going to appear in the submitter field. You need to indicate the docket number, enter the filing title of the exhibit, which I am repeating for you when we are talking about those exhibits, or you should have it written on the exhibit. You find and highlight the name of the company or entity for which the filing is made. And finally, if the board has ruled that that is a confidential document, we would ask that you put that information in to the filing information. If you do not file an exhibit in the electronic filing system, it will not be made part of the record. And there are a number of exhibits that are apparently not being filed in EFS that are being presented at the hearing. So the board is directing that you are required to file a hearing exhibit. Will you clean that up? In order for it to be part of the record. Are there any questions?
The timing of the filing, may that follow the hard copy introduction that we've been using?
Yes.
Thank you.
The problem isn't with those that are being filed, it's with those that aren't being filed, or the identification of who the party is or whether it's confidential. And if you need assistance with this, you may call 515-725-7337. Any questions? All right. Ms. Sorensen, do you have your mic on? I'm going in that. Please raise your right arm. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated, Ms. Sorensen. Could you please state your name and address for the record?
Linda Sorensen, 3291 Mississippi River Road, Keokuk, Iowa.
Did you file with the board prepared written testimony?
Yes.
Do you have any changes to your testimony?
Yes. On Exhibit 1, page 5, line 1, I misspelled the word aerial. It should be A-E-R-I-A-L.
Do you have any additional changes?
Yes, in my testimony, page 2, line 16, the word attempt should be inserted I will attempt to reveal. And then finally, I'm not sure how the board wants to handle it, but I made a number of references in my testimony on page 6 to the SEC report of Raybar Daniels, and I did not identify the page from which it was taken. If the board, I will gladly do that, but I will need till Monday because that report was over 400 pages, and I just discovered this morning that I had not specified which page those references were from.
Provide us with the page at the point that you obtain that information, and we will make it part of the record.
And may I have till Monday to do that, please? Because, it's buried in there.
Yes, but will you make sure to remind me
Oh, yeah,
that I need to add that?
absolutely,
Thank you.
absolutely.
Do you have any additional changes to your testimony?
No,
Do you adopt your prepared testimony today?
yes,
Did you file any objections in this
yes.
Do you adopt your objections?
Yes,
Did you file any exhibits in this docket?
with my testimony, yes.
And those exhibits are 1 through 7, 1 through 8?
Well, it's I think it's 1 through 6, and number 4 has an addendum. I think that's the way it's listed in the filing system.
So with your testimony, you have 1 through 5.
Oh, excuse me, let me take that back. I had messed up on number 5, and so I revised it and resubmitted it, so I'm not 100% clear myself on how these are numbered.
Well, that's what you and I are going to try and do. So let's start with Exhibit 1. Ms. Sorensen, in the electronic filing system, we have listed exhibits 1 through 5.
I thought it says 1 through 6.
Okay. In your testimony, you have exhibits 1 through 6. So let's start with Exhibit 1.
Okay?
Do you recognize or are you familiar with this exhibit?
Yes,
Was it prepared by you?
yes.
Where did you obtain the maps?
Different ones from different places. Obviously, I need to go back, and a large number of them were from Dakota Access.
Just a moment. Mr. Dublinski, on Ms. Sorensen's exhibits 1 through 6, do you have any objection to their admission?
I do not, Your Honor.
So exhibits 1 through 6 are admitted. In addition, Ms. Sorensen, it's my understanding that you have, is there anyone else that has objections to exhibits 1 through 6? Seeing none, they are admitted. Exhibit 7 is a hearing exhibit.
I didn't think that was accepted.
So one of the things that we're attempting to do is lay a foundation for which the board can accept this as part of the record. So the question that I have for you is, do you recognize this document?
Yes,
Was this document prepared by you?
yes.
Did you review what did you review to obtain this information?
The EFS system?
So the Iowa Utilities Board electronic filing system.
Correct.
To the best of your knowledge, you prepared this document based on your review of the electronic filing system.
Correct.
And are you wishing to offer Sorensen Hearing Exhibit 7 into the record?
I would just assume not.
Okay. Do you have any other hearing exhibits?
I don't believe so.
Do you have hearing exhibit 8? Sorensen Hearing Exhibit 8.
Okay, you'll have to tell me what the title,
This is an
okay.
addendum.
Okay, yes. I called it Exhibit 4 addendum, you call it 8, that's fine.
Can you tell me what Exhibit 4 addendum is?
In Exhibit 4, I had said that we had requested lab reports. At the time, the lab reports were not back, and I said that, that when they were back, I would provide the board with a copy of the lab reports. This is the copy and some notes.
And did you prepare these documents?
The State Hygienic Lab prepared most of them, and there's a small summary at the end that my husband wrote.
And this report is based on what information?
We had our well water tested just as a baseline, so that in the future, if there were any problems that might be associated with the pipeline, we would have a baseline.
And are you wanting to offer into evidence Exhibit 4 addendum?
Yes.
Is there any objection to the admission of Exhibit 4 addendum?
We don't object.
Hearing no objection, it's admitted. Can you please pull up Ms. Sorensen's county map? Ms. Sorensen, do you own property that is subject to the proposed pipeline?
No. We own land that's 2/10 of a mile from the center line of where the pipeline would be. Or is proposed to be.
Mr. Lozier, do you have questions for the witness?
No, we have no questions.
Mr. Piazza,
No questions at this time.
Mr. Dublinsky,
No questions, Your Honor.
Mr. Pauly,
No questions.
Ms. Jacobs,
I have no questions.
Mr. Wagner. Is there anything else that you think the board should know related to your testimony?
I think I just barely touched on it, but an area of concern to me that has not, I don't believe, been brought up in the hearing so far is in relation to the jobs. And my concern is that the high-paying jobs will largely go to out-of-state people, and the lowest-paying jobs will be like hotel workers or fast food people. But it's the third tier, the people who will be operating the backhoes and the bulldozers, I'm afraid that those jobs will go to Iowans, and I'm afraid it will tear the social fabric when Iowans are literally involved in, I hate to use the word destruction, but of their neighbors' property. I think, especially if it's taken by eminent domain, I just think there will be a social backlash, and it's not the way Iowans operate, and I'm concerned about that. Beyond that, I know the board is very bright and very knowledgeable, but you're young, and I'm just afraid that maybe you won't have enough wisdom. And so I hope that if there are sources that you can go to for wisdom, that you do that in your deliberations.
Thank you. And thank you for saying that we're young.
Believe me, almost everyone is. Is that it?
Yes, Ms. Sorensen, and thank you for your testimony. Judy, we're going to go off the record for the court reporter. Judy, can you go see if you can locate Miss Grunhagen or Mr. Murray? Are there any other issues?
Your Honor, I don't know if it's anything, if you want to deal with it now or not, but just a reminder that the board still has under advisement whether or not it's going to admit the supplemental testimony of Mr. Dorshik, and just for preparation reasons for tomorrow, it would be beneficial for us to have a ruling on that.
We do have a ruling on that. We were waiting until the testimony, but if you would like me to rule now, what would you like, Mr. Dubinsky?
I infer from that you're going to allow it, but either way, it will affect our preparation. So as long as we have it by the end of today, so we know what we're preparing for in terms of the exam tomorrow.
We are going to allow the correction of testimony and the addition that has been presented. We are also allowing you to bring Ms. Howard back on for rebuttal based on that testimony. We would prefer that it be live testimony versus a written document submitted so that we can make sure it's on the record as soon as possible. So Ms. Howard, is that enough, Mr. Dubinsky? Do you need any additional information?
I don't believe so, Your Honor.
All right, thank you. Ms. Grunhagen, we attempted to admit Mr. Peterson's testimony into the record, and it's our understanding that there are two parties that have questions for him. Related to that, there is a question as to whether or not it's friendly cross, and I would like to hear the motions made by Mr. Murray and Mr. Puntney, and then would like a response from you. Mr. Murray, Mr. Puntney, who would like to start? Mr. Murray? You can fight about it over there and let me know which one.
I'm going to withdraw my questions for Mr. Peterson.
Mr. Puntini?
I have reviewed the document again, just to refresh my memory. He makes a number of suggestions on things he would like to see adopted by the board in support of the Farm Bureau's, policies and procedures. He doesn't really state a narrative as to how those procedures should be adopted or enforced or handled, and I would like him to explain further so that that could be understood by all of us. Some of them go to the easements, some of them go to issues about notice to farm agencies and farmers, and some of them deal with, I believe, Tom Fenton's soil science stuff, information that was given today. And so I would like him an opportunity to give him to expand upon his testimony so we have a clear understanding.
Mr. Polly, so that you can prepare, or Mr. Long, I don't care which, but I am going to ask you whether you believe the testimony is neutral or takes a stance on one side or the other. So I would ask that you prepare for that. Ms. Grunhagen?
What Mr. Putney is asking for is an expanded explanation of the direct testimony. I don't see that the questions that he wants to ask reflect that the questions are adverse to that testimony and that it would be a friendly cross-examination.
Mr. Dublinsky?
Your Honor, I think from our view, Farm Bureau is neutral perhaps in a different sense than OCA, which I think is a neutral party. Farm Bureau took a position that I think is favorable towards Dakota Access's position in some parts, and had some concerns about Dakota Access's position in others. Now that I've had the opportunity to hear the line of questioning Mr. Puntney is suggesting, it is clear that all of that goes to the part that in fact would be friendly cross from their side. Obviously, I don't mean to speak for Ms. Grunhagen, but it certainly appeared to me that it was intentionally written, at both parts, by the way, at sort of a high-level 40,000-foot view. And if that was intentional, I don't know that it's appropriate for Mr. Puntney to try and extract additional friendly material from that testimony. So we would object.
And Mr. Polly, if you don't want to respond, that's fine. Okay, thank you. The board's decision is, Mr. Puntney, that would be friendly cross based on the information that you've provided us. If you choose to address those issues, you will have that opportunity in the post-hearing brief.
Okay, thank you.
At this time, Ms. Grunhagen, you are moving to admit the testimony of Mr. Peterson. Having addressed any of the objections or issues that have been raised, we will admit the testimony. And thank you for attending. Mr. Murray?
Before calling a witness, and after consultation with Dakota Access's attorney, I think I ought to clarify something concerning Exhibit KLJ-1, the approximate 1,000-page filing, and which was distributed to parties last night. Okay. This was the right-of-way discussions with landowners in the records, okay?
All right.
What I wanted to note, and I don't know if this is a motion or what, but first of all of my witnesses, and I'm going to make it of the record here, all my witnesses are that I'll call will be clients. I don't think I've clarified that for all my witnesses, but for the record, they're going to be clients and therefore bound by the confidentiality. Okay. The next thing, and I should note that I brought this up to Dakota Access Council. They didn't bring it to me, but I think others in the room ought to know the procedure that might be followed. I find it important for the sections of that 1,000-page document to be reviewable by my clients so that they can look at it and react to it. Now, Ms. Chair has asked me to put a couple of witnesses on today because there's some time. I'm fine with that. But my witnesses / clients have just not had a fair chance to look over those records completely. And the fact that they've had a chance to look at it for 10 minutes in no way should mean that if they don't say anything about it, it's deemed correct. I want that to be noted for the record. But I also wanted to note that they are limited by agreement of council only to those sections of the right-of-way notes that pertain to them. So, for example, Mr. Lambert, I searched for Lambert, and he was able to look at those pages, but no other pages. And I've got Mr. Lamb today, so searching for Mr. Lamb was kind of fun. He was able to look at his land and his wife's land, but no other property. So I think we ought to clarify about the confidentiality of this document, Ms. Chair.
Mr. Dubinsky?
Your Honor, and while I appreciate Mr. Murray's consulting with me about that, as I told him, we would have significant objections. Certainly, it is not our understanding of how the process is supposed to work or what the purpose of that exhibit was, and we talked about this a little bit yesterday. That exhibit is only in the record because the board asked for it after some discussion with Mr. Johnson to provide it itself with some additional context for what Mr. Johnson was talking about. The discussion that Mr. Murray is saying that he needs to have with his clients, and I understand the chair said, they ought to be entitled to get it in time so they have it before I cross-examine their witnesses, which I thought was generous, but we did not object to. But the scenario that concerns me, and what I understand from Mr. Murray, is that even if I pass and no one ever brings anything up in the scope, or for that matter, even if somebody does, but it's someone other than us, he wants to then be able to raise issues from those notes through his witnesses. First of all, that is beyond the scope of their direct. Second of all, the private parties have had since January 20th, 2015 to engage in discovery. Nobody ever asked for that. They should not be able to profit from the board doing their work for them and say, just because the board asked for that, we now get to reopen an avenue in the case that we chose as lawyers and represented parties not to explore, because then we would need to be able to come back in behind that. We hadn't prepped. That wasn't part of the direct. It wasn't part of discovery. It wasn't part of the case. At some point, the universe has to close, and in normal civil procedure, that would be their burden to make their case, not the board's burden or their ability to piggyback on the board's own due diligence. So we would strongly object at this point for them getting to do any supplemental testimony of a direct nature based on those notes. I mean, obviously, if we cross somebody on those notes, which the board said we had to make available to them exactly in preparation for that, that opens the door. But if we don't, those notes should not be able to come back in through some sort of a supplemental testimony process at this point. That defeats the entire purpose of private party discovery.
I'm interested in hearing your response to this statement before I have a conversation with the other two board members. My recollection of why we asked for the information is because I became irritated with the witness not answering the questions and not having the information related to who the land agent and other individuals were and the conversations that had occurred. Large number of conversations, large number of different landman, man or land agent, whatever we want to call them. But that's my recollection of why we asked for the information, and we had no idea how extensive it was. But is that your recollection, or do you remember it in a different manner?
Your Honor, I don't want to characterize.
You don't have to use it as irritated. You can, yes.
I don't want to characterize why you asked for it. I would say now that it's on the record that I respectfully disagree with the chair about whether the witness was offering inappropriate answers in response to the type of questions that were being asked. But for whatever reason, I do agree that the board asked for it to help provide information that was contextual on, for example, the names that kept coming up on who the land agent was. I would also say, and I think certainly staff is aware, and likely all the board members are, it is not unusual in these linear project cases to have a supervisor as opposed to the individual land agents, nor is it unusual for those contact notes to not be submitted into the record. In fact, in my experience on linear projects, it's relatively rare that they are. We were happy to provide that for the board for whatever reason Your Honor wanted it. I don't think it changes the argument that it's inappropriate for the other side, who didn't ask for that for months of having a chance, to piggyback on that at this point.
I appreciate the way you recharacterized that situation. I just wanted to make sure I remembered correctly when we asked you to provide it, and in no way am I addressing the other issue in this objection.
No,
so I will.
And again, the one thing I would add is that normally, I think Your Honor's aware, I mean, this has been a somewhat unusual case in a lot of ways, admittedly. But this is the sort of thing that normally when the board has a request for additional information for its own purposes is actually done as a post-hearing late filed exhibit where this issue would never come up. This case has been somewhat unusual in that the universe of the case has been essentially a moving object throughout, right? There's been a lot of real-time filings of additional information. That is the exception, not the rule.
Sure.
Your Honor?
So, Mr. Dumblinsky, in that case that you just mentioned, typically, how would that evidence be addressed? Would that be through briefs?
It would be through briefs, and obviously that is a concern when it happens. But I don't think it's. I think everyone on the board is aware that it certainly does happen. I mean, even in sort of big things like the Mid-American rate case, there were things that the board said, can people file that after the close of the hearing? Those do become part of the evidentiary record if there are concerns. Those are handled in the briefs. But it does make it difficult to prepare, obviously, when the universe of the case is changing in real time. And as the party that actually, and the only party that actually has the burden in this case, I think we are sort of uniquely prejudiced by that.
So then if and I think I heard you correctly, that the board asked for that for a specific purpose, and not of which was to look at what is specifically contained in there. How does then, now the genie's out of the bottle, how does the board restrict our use of that document to ourselves?
Well, I think that the board can use it, obviously, for the purposes it wants. I think the parties can brief it. If Mr. Murray looks and says, well, in these notes, it says something that's, supports what my client has said all along or whatever, he certainly is free to do that. But again, my concern is that if he wanted to make any greater use of that, he could have asked any of the parties, could have sent a discovery request that said, provide any notes of contact with my client. And since January 20th, 2015, not one party has done that. The board shouldn't be in a position where, intentionally or otherwise, you're doing the lawyering work for the opposing parties.
I would agree with that since I'm an engineer.
Mr. Puntany?
I guess I would like to address part of what Mr. Dublinsky said. First of all, the time period for discovery and everything else has been very compressed. There have been a lot of motions back and forth and clarifications back and forth on how all of this was to be done. And some of that compression included your rulings that limited the number of items of discovery that could go out. So there had to be some prioritization as well as, I guess, negotiations between people on this side on who was going to take what issues and go forward with discovery. Second, as you can tell, there's a limited number of attorneys that are involved in this process, and including people like myself who retired and ceased to be attorneys a long time ago. So the process we're undergoing here is substantially new to many of us, and while I perfectly understand Mr. Dublinsky's arguments, I think all of us would agree this is a fairly unusual case for lots of reasons. Okay, time and everything else being one of those. The issue of the notes and everything is obviously not new. We all knew that this was going on as we were talking to land agents and everything else. But for most of us, this is a new process. I mean, not many of us have gone through this process in our lifetime, before. So availability of notes is, yes, an issue. But again, in terms of preparing for this, given the number of witnesses and everything else that have gone into it, I think the priority has been to try and prepare for the big issues, and this was one that frankly most of us did not put on the top of our list. So while I understand his argument, I think the relevancy of it is directly applicable to your role in terms of evaluating whether they have carried their burden. And I think briefing it doesn't do justice to having everybody in this courtroom ask questions if that's what is necessary and go on the record. So I would simply argue that if Mr. Dublinsky needs more time, then we need to deal with that in some other fashion. But I think it's relevant to the landowners. It's relevant to the fairness and reasonableness of the negotiations. It's relevant to the argument that was just made by the Farm Bureau representative that the IUB should look at the negotiations and determine whether or not there was a fair and reasonable effort made to get this done in a voluntary sense. And I think it goes to the heart of the issue of eminent domain for those of us who are identified as eminent domain people. And along that same argument, the final route wasn't determined until very late in the process. I mean, it's shifted some in terms of the process. There are some people who've dropped out and some people who have been added. We knew from the very beginning it was a 3/4 mile route, and it's shrunk down as this process has evolved. So in looking at this from the perspective of a landowner or somebody affected by this property, it wasn't until we got to the final Exhibit H filings that we knew we're here, we're now. We got to do something in terms of that whole process. So I think both sides have been prejudiced, if you will, by the time issues that are there, but I think this is a relevant issue.
Mr. Murray?
I think Mr. Dublinsky is characterizing this as a discovery dispute, and I would rather disagree. I think the board needs to look at this from the perspective of its own staff memo when it pointed out early on, I think, was it August, that they need to show proof of good faith. Following that, my witnesses filed testimony on time that showed very strong issues of good faith negotiations or lack thereof. So they have the burden of proving that, and they've apparently think they can follow that burden or carry that burden by giving us a 1,000-page document last night.
Your Honor, that's an extreme mischaracterization. We addressed that in our testimony. The board asked us to file the 1,000-page document last night. For Mr. Murray to suggest that some sort of game that we're playing just simply couldn't be more of a lie. That is just simply wrong. Let me address Mr. Putney. He said that the time has been compressed. Again, nobody made the interveners wait until July 27th. Intervention was a possibility anytime after we filed, and even after July 27th, there was still months before we got here. He talks about we were limited, that the board somehow limited them in the number of data requests, but even at the limit of, I believe, 15 per opposition party, that adds up to over 100 data requests. I can professionally represent they did not use anywhere close to their entire complement. So to suggest that the board's limit kept them from asking for these notes, again, is simply not supported by the facts. The notion that they are somehow not used to the process enough to understand, they managed to ask plenty of discovery requests nonetheless. Nothing about their lack of experience should have made a difference whether they happened to ask this one. And frankly, Mr. Prey and Mr. Hannigan are from two of the most experienced utilities laws firms in the state of Iowa. What it really comes down to is Mr. Putney himself said, this is about priorities. Clearly, this was not a priority for them until they saw an opportunity to get a windfall from what the board had asked. They shouldn't be allowed to do that. It's just that simple. This notion that, well, if Dakota Access needs extra time, that's fine. That's easy for them to say. For them to filibuster the project is advantageous. Delay, really, we're the only ones that are significantly harmed by that. At the end of the day, the process, all of the process, has to end. This state has allowed discovery to be open longer than any of the other 3 states on the line. There's been no shortage of time. There's no prejudice to them. As Mr. Putney said, the board should have this information. Fine, the board has this information. It asked for it. We gladly turned it over on a confidential basis. But that needs to be the end of it. The process has to stop.
Your Honor, if I might interject.
Yes, Mr. Pauly.
I'm not sure I want to address whether or not this is a discovery dispute. I don't believe it is. This issue of late exhibits at a hearing comes up on a regular basis before the Utilities Board. And every time it comes up, due process issues are raised. And I believe this is no different. Parties who may be affected by the information that is filed with the board have a right to not just examine that evidence, but at some point they have a right to address it. That's the essence of due process. I don't think that the fact that we may take an extra day or two at hearing to allow that to occur unduly prejudices anyone. I think what we have to do, what my office recommends, is that the board do its best to give and respect the due process rights of the parties involved. And if those and the 1,000 pages don't all apply to any of the parties here. There are only certain pages apply to the people who have intervened and who are part of this proceeding. And they should have the right to look at that information, and if they see something that they believe is wrong or incorrect, I think they have a right to bring to the board's attention that issue. We can do that, I believe, without unduly prolonging this proceeding. It may take a day or so extra, but so be it. That is the price we pay for having due process rights. Thank you.
Your
Mr.
Honor,
Dubinsky?
with all due respect to Mr. Polly and the role of the Office of Consumer Advocate, first, just to clarify, the 1,000 pages are only those persons who are parties to the case or witnesses or who were discussed in the testimony. So it is already narrowly limited to that. Again, Dakota Access also has due process rights. We have rights to have procedural normality, to have procedural rules followed. We have rights to have some ability to put on our case, since we're the ones with the burden, in a way that that reflects our strategic decisions. If being able to pass on a witness has no ability to limit their scope, if being able to count on what was made part of the universe of discovery is not at all in our control, that affects our due process rights as well. There are limits to due process rights. Being here in the hearing, having had the discovery opportunity in the first place, being able to cross-examine witnesses based on the discovery that they did do, that's what due process requires. There are plenty of Supreme Court cases that say that in an administrative agency that the due process requirement is somewhat flexible and fits the needs. Again, we think that it's hard for anyone to argue that in a case that's been going on for over a year since it was first filed, and that's going to have nearly 4 weeks of hearings, that anyone is going to be able to make a claim that there was an absence of process here. But again, to the extent that there are process concerns, I understand that, you know, we're the company, but we also have procedural rights. And all we're asking is that those not be overlooked, and that the process leading up to this means something. The choices litigants make are not something that it's not this board's job, or again, with no offense, OCA's job, to save private litigants from.
Your Honor,
Yes, Mr. Murray?
at the risk of submitting a lie further, and I think maybe Mr. Dubinsky regrets that word, I would offer to the board that with respect to all of my witnesses that are listed on Monday, I would not require additional time for those witnesses. As Mr. Pohl, I'm sorry, noted, I just need some time to have those guys look at it and go over it. But with respect to the 2 witnesses today, it was hard for me to get through it. That's all I'm saying. Thank you.
And Your Honor, this is not about additional time necessarily just for them, but if they get to come in and essentially change the course of the direct testimony, we will then need time to prepare for that, potentially to call witnesses back as rebuttal witnesses, which, you know, we thought many of our witnesses were released. And again, the ability to have some control over the scope of the case and to get this thing to a conclusion so the other side can't filibuster it matters.
The Utilities Board will take a 10-minute recess.
Madam Chair, can I add one quick thing? It's also in our interest to get this done.
Just a minute.
Okay.
Edie, just keep.
Okay. Thank you. It's also in our best interest to get this done, because obviously if we have any appeal rights before they put the plow on the ground, as they said they're going to start in February or March, a quick resolution works in both of our interests. This is not about us filibustering or trying to delay this. This is simply about us having the opportunity to look at some information. Thank you.
Thank you. The Utilities Board is back in session. Mr. Murray,
Yes?
in plain English, what exactly are you asking the board to do?
With respect to Mr. Lamb and Lambert, they need to have the ability to have a time to review Exhibit KLJ1. And then if after today I need to recall them for that purpose only, then I would, by Monday, should be allowed to do that.
But what are you intending on recalling them to do?
To address the information.
Are you asking for us, for the Utilities Board, to consider allowing live testimony?
On Monday, as late as Monday, concerning that, yes.
Mr. Murray, are you aware, Mr. Dublinsky, to your knowledge, is KLJ1, what document is that?
KLJ1 are the collection of CLS contact notes with the landowners who are either parties, witnesses, or who were mentioned in Dakota Access testimony in this case that was requested by Your Honor when Mr. Johnson was on the stand.
And at this point, is that document admitted as an exhibit?
We filed that at your request. We assumed that the intent was that that would be an exhibit. You had asked us to serve the other parties with that, so we have labeled it as exhibit KJH1 or KHJ1, and it is in the EFS accordingly. Confidentially, I should add.
Is it your belief that it's been admitted?
We have not moved it. Your Honor requested it and asked that it be served, but that's, I don't know what its
I'm trying to
status
make
is.
sure
Yeah.
that my understanding is the same as yours. Is that your understanding, Mr. Murray?
I'd have to look at my notes. I don't know.
We're going to go off the record for a moment. Either of you know what the 24-hour rule is? You don't send an email back until one of those you don't want to send until you've thought about it for a while. Well, the board is going to think about this and how we want to handle it because of all of the issues that have been raised. So it's my intent to go back on the record. I'm going to inform you that the board needs to think about its decision on this matter, and we will wait for Mr. Mahmood to arrive. Mr. Murray, we believe that other than the inconvenience that has been provided to your witnesses, that we'd like them to stay for a bit, but it's likely we'll just move them back to Monday. So I want you to be aware of that, but we are going to recess then, and I'm going to go back on the record. The board would like to take this issue under advisement, and because of that, your witnesses can be moved back to Monday to testify and stick around for a bit, but it's your call on that, and then we'll wait for Mr. Mahmood to arrive.
I just got the nod that it's okay.
All right. So we will move them back to Monday, and we will have a ruling for all of the parties tomorrow morning at 8:30. So you know when we're starting. And we will recess until the arrival of Mr. Mahmood. Questions? All right, we are recessed.
Yeah, I was going to say,
That's what I didn't see the other mic. We're back on the record. Mr. Dublinsky, could you please give me an approximate location of Mr. Mahmood at this moment?
Mr. Mahmood is in an airplane between North Dakota and here,
All right, and is he flying into Ames or
Yeah.
Des Moines?
Ames.
Okay. Does everyone have their witness list? Tomorrow morning, we are going to begin at 8 a.m. I want to know what witness will be here at 8 a.m. Mr. Mahmood? Yes?
Yeah.
Okay.
Yeah.
Mr. Immerman will then, as soon as he gets here, we'll switch to Immerman, Dorshuk. Correct, Mr. Taylor? 10 a.m.?
Yeah.
Mr. Sanderin, we have, and teach me how to say that, Raffensperger. Oh. And then we have Wehrman Anderson. Mr. Wells. Mr. Swinson, is that correct, Mr. Taylor?
Yeah.
Anderson, Feldstein, Johnson, Larson, Lohman, Rasmussen, Rook, and Williams, Mr. Murray? Are those, oops. Are those, no, they're praise.
Those are praise, I think.
So, Mr. Prey, I'm assuming they're all going to be here if you're watching. Magram, and throughout the day, Mahmood. This is your notice that that's the order we're going to follow tomorrow.
I just
Bakken. Fairfield.
all right.
Mr. Murray, I heard Mr. Prey call you co-counsel yesterday, and for that reason, I am directing you to inform Mr. Prey that he needs to be prepared for any landowners that he has that are scheduled to testify for any ruling that is made by the board. The board is planning on recessing until 8 a.m. tomorrow, and therefore he needs to inform his landowners if either way, he needs to be prepared for that testimony. We will make a ruling at 8 a.m.
Concerning, I think, my motion.
That's correct. That's why you're the appropriate person to call him and fill him in on this as co-counsel.
And because I'm the co-counsel extraordinaire, and Mr. Swinton had the similar request of me, I was wanting to clarify Immerman. Did you say he was going to be first or Mahmood?
My concern is we've been starting at 8:30, and if Mr. Immerman isn't here at 8 o'clock, I'm going right to Mr. Mahmood,
Okay.
and then we'll switch to Mr. Immerman when he gets here. I don't want to not have somebody lined up to go.
And just to let you know, Mr. Swinton and I did have a conversation about anything that might happen scheduling wise. I'm going to let him know, and we'll make it happen for 8 a.m. on Immerman. Okay?
Perfect. So Mr. Immerman will be at 8 a.m. Mr. Mahmood will be fill-in throughout the day when we have spacing. And I would ask Mr. Dublinsky that you allow us that flexibility. And we've gone through the remainder, other than Mr. Sandgren, who Mr. Wright will contact. Is there any other party that needs to be informed? So it is the intent of the Iowa Utilities Board to recess until 8 a.m. Thursday, December 3rd.
Ma'am, may I ask one quick question?
Mr. Puntany,
Thank you. The testimony tomorrow with Mr. Mahmood will all be closed session, is that correct?
no.
Okay.
We left with Mr. Long, who will start in open. The board has a number of questions, I know, and then Mr. Dublinsky will have the option of doing redirect at that point in time, and then we will go into closed session with Mr. Mahmood in the afternoon.
Thank you.
Madam Chair?
Mr. Taylor.
Thank you. With respect to Mr. Immerman's testimony, I gave notice the other day, and we kind of postponed it until he actually testified, but I requested permission to cross-examine Mr. Immerman. The reason is that I want to establish that the implan model that he was critiquing with respect to Mr. Lipsman's testimony does not include an analysis of costs, only benefits. And I want to establish that Mr. Immerman's testimony didn't address costs and risks of the project. And I want to establish that his testimony doesn't consider that Dakota Access is externalizing the costs and risks of the project to the public, such as costs of spills, impacts on climate change, impacts on the environment, and impacts on landowners. That's why I think to the extent that I want to cross Mr. Immerman on the fact that he didn't include those issues in his analysis is a proper cross-examination and is not a friendly cross-examination in the terms that the board has defined it.
Mr. Dublinsky.
Your Honor, I have no idea why Mr. Taylor would need to ask that, having just done a fantastic job of testifying to that effect. But I think that's clearly friendly cross. And it's also hard to see how he's going to get that point in without, again, frankly, testifying when he asks. The fact that those may be things that he could get out of Mr. Immerman that were different than what Mr. Immerman did, doesn't somehow make it hostile. They still are on the same side of the case. He's still trying to make favorable points from a favorable witness. And frankly, I think Mr. Lipsman already answered that question from Mr. Taylor with regard to the M-Plan model and what it looks at and what it doesn't. So it's redundant, it's friendly, and the only way he's going to get there is if he testifies. So
I would just say, I think the Iowa Supreme Court, as we noted in a pleading that we filed, has been very clear that cross-examination should be limited only in very extreme circumstances where the questioning becomes repetitive or it's clearly softball questions. These are not softball questions.
And Your Honor, I can equally cite Supreme Court cases, including some that I've been in, both on adverse to the board, that the Supreme Court has said that for the administrative agency, that is a more flexible standard. In many cases, the board isn't required to allow cross-examination at all, and the tribunal has great discretion in how to, manage that sort of issue. There is no requirement to allow friendly cross. It's just that simple.
We will rule on that prior to Mr. Emmerman after he's sworn in tomorrow morning.
Thank you.
Are there any other issues to come before the Iowa Utilities Board? Seeing none, we will recess until 8 a.m. Thursday morning.